foresee that causing the package to drop here on the tracks would bring about some danger to Ms. Palsgraf, who was standing a good 50 feet away under a scale. Oh, maybe if the package had been labeled danger TNT, then the ordinary person seeing the package would have realized that if it fell, that would pose a danger to Ms. Palsgraf. But there really wasn't anything about the package that would have placed the ordinary person on notice that there was a possibility of danger to Ms. Palsgraf. So Ms. Palsgraf was not a foreseeable plaintiff, and the railroad did not owe her a duty of reasonable care, and that's why Ms. Palsgraf lost her case. Now, Judge Andrews wrote a dissenting opinion in that case, and many people have become confused about what it was Judge Andrews had to say. As a result, you're going to come across some people who insist there's an Andrews view of duty and a Cardozo view of duty. And I'm going to tell you very briefly what that was about. I don't think Judge Andrews thought that Ms. Palsgraf ought to win her case either. But Judge Andrews thought that in deciding that her case should be lost, we should use a different kind of reasoning. Judge Andrews suggested that Ms. Palsgraf's case should have been decided on the issue of proximate cause, which is something you and I haven't talked about yet, and so we're not going to talk about it now. And in order to say that, he kind of had to say duty is not the right approach at all. You see, everybody should owe everybody else a duty of reasonable care. Well, that wasn't the law. I really don't think Judge Andrews thought it was the law. In any event, nobody really thinks it's the law now, and there really is no such thing as the Andrews view of duty. I don't really think it's worth discussing on an exam, and I don't think it's worth taking very seriously. And I think that when you study proximate cause, you ought to go back and again read what Judge Andrews had to say in his dissent in Palsgraf, and I think then it's going to make a whole lot more sense to you. But at this point, I think we're going to recognize that most of the time the courts agree that if it was not foreseeable that there would be danger to someone in the plaintiff's shoes or in the plaintiff's situation, then the defendant did not owe the plaintiff a duty of reasonable care. And I want to warn you about this, and the warning that I'm going to give you is going to be a warning that you should really apply to every rule you learn. You know, there are lots of times when you don't have to talk about that rule at all. There are lots of times when the answer to the question, was there a foreseeable plaintiff, is so obvious that there really isn't any need to discuss it. I'm going to give you an example. I'm driving my car and I'm driving too fast and I collide with the car in front of me. Well, if the guy in front of me sues me for negligence, I don't think anybody is going to waste time arguing about whether it was foreseeable that my driving would endanger him. After all, there are so many ways that a car can go astray on a road that when you drive a car on a road, it's foreseeable that you'll injure the person in front of you, the person behind you, the person to the left, the person to the right, hey, probably even the person on a sidewalk. If I collide with the guy in front of me and a piece of my car goes flying through the air and strikes a person on the sidewalk and he sues me for negligence, I don't think my lawyer is going to spend a lot of time trying to say that he wasn't the foreseeable plaintiff and therefore I didn't owe him a duty of reasonable care. Because after all, when automobiles collide, frequently things go flying through the air. Now, suppose the plaintiff was in the second story of a building located adjacent to the road, and through some fluke, a piece of my car went flying up to the second story through the window and injured the plaintiff. Well, if that plaintiff sues me for negligence, I think there's a pretty good chance that my lawyer is going to try to argue that she was not a foreseeable plaintiff, and that therefore, when I drove my car on the street, I did not owe that plaintiff, who was in the second story of an apartment building or an office building, a duty of reasonable care. Hey, how about this one? Just as I collide with the car in front of me, an airplane is passing overhead. It just took off from a nearby airport, and it's just retracting its wheels into the plane when a piece of my car went flying through the air and got caught in the airplane's wheels and got taken up into the plane. And the airplane kept flying, and it traveled about 3.5 hours, and it flew to Chicago, which is 3.5 hours away from where I am now. And as it was coming in for a landing at O'Hare Airport in Chicago, the pilot put the wheels down, and lo and behold, that piece of my automobile fell out from where it had been kept in the plane and dropped onto the head of some pedestrian who was walking at the airport. And he struck by the bumper from my car. My accident happened, let's say, in California, which is where I'm speaking to you from. That person in Chicago who got struck with the bumper of my car sues me for negligence. Hey, I'm pretty sure he's going to lose his case, because the chances are that when I drove my car in an unreasonable manner here on the street, on Main Street, California, the reasonable person would not have anticipated that anything I did could have any effect at all on a person in Chicago, 2,000 miles away from me. That plaintiff was not a foreseeable plaintiff, and so the chances are I did not owe him or her a duty of reasonable care. Now, I could change the facts and maybe change the conclusion. When I was driving my car, I was carrying armed nuclear bombs in the trunk. I don't really know if a nuclear bomb will fit in the trunk of my car, but it's my hypo, so I'll put it the way I want it. And when I collided with the car in front of me, those nuclear bombs exploded, and that set off World War III, and somehow during the course of World War III, that fellow in Chicago was injured. Hey, maybe he's got a negligence case against me. There are probably other reasons why he won't, which we'll talk about later, but maybe he's got a negligence case against me, because maybe when you drive around with armed nuclear devices in your automobile, it is foreseeable that if you have an accident, the person 2,000 miles away will be injured. Certainly that argument could be and would be made. Okay, let's talk about another important factor that the courts consider in deciding whether the defendant owed the plaintiff a duty of reasonable care. And that factor is whether the risk to the plaintiff was caused by the defendant's affirmative conduct. Because most of the time, if I see you suffering, if I see you in danger, and I'm not the one who put you in danger, I have no obligation to help you, no obligation to get you out of danger, no legal obligation. Of course, we're not talking about moral obligations here. Unless the reason you're in danger is because of some physical affirmative act that I committed. I'm going to give you an example. I'm at a restaurant with 9 of my friends. In fact, my 9 friends are medical doctors, and I'm a juris doctor. If you have a sick jurist, give it 2 aspirins and call me in the morning. And we're enjoying our dinner when suddenly we look over at the next table and there's a stranger there and he's choking on a chicken bone. Now, 9 of the people at my table are medical doctors, and gee, I know the Heimlich maneuver. Any one of us could have helped this fellow that was choking on a chicken bone, but we chose not to help him. We looked at him, we watched him choke, maybe even took bets on how long it would take before he choked to death. Did we have any duty of reasonable care to help him? Well, no, because we're not the ones that put the chicken bone in his throat. We're not the ones that committed some affirmative act that put him in danger. So maybe we form a circle around him and we start singing and dancing. Chicken bone, choking on a chicken bone. Have we any duty of reasonable care to this fellow? Well, still not, because we are not people who created the risk that he faces. We didn't do anything to put him in danger, and so we don't have any obligation to get him out of the danger. We continue singing and dancing in a circle around him. Chicken bone, choking on a chicken bone. When along come the paramedics, and the paramedics want to get to the fellow and give him the Heimlich maneuver and CPR and save him from the chicken bone on which he's choking. But we're in this ecstasy of song and dance, and we're holding hands, and we're snake dancing around his table, and so the paramedics can't get through to him to apply the Heimlich maneuver and the CPR and whatever else they would do for him. Now, have we a duty of reasonable care? Well, have we committed some physical affirmative act that placed him in danger or increased the danger he was in? Well, we sure have. We prevented the rescuers from getting to him. Now that our actual act has increased his danger or changed the danger that he was in, now we have a duty to act reasonably in the face of his danger. Probably it would be enough if we just got out of the way and let the paramedics get in. But what reasonable care means is tied to the question of breach, and right now we're talking about duty. So remember that rule. If I have not done something to place you in danger, if I have not done something to increase your danger, the chances are I have no obligation to get you out of that danger. I'm driving down the street, and I notice lying by the side of the road is a fellow that's had an accident. He's fallen off his motorcycle. The motorcycle is smashed, and he's bleeding. And I look at him, and I know that if he doesn't get help within the next few minutes, he'll probably bleed to death. And I decide to do nothing about it and drive by. Did I